number 52, Tomhannock versus Roustabout Resources. Good afternoon, Counsel.
Good afternoon, Your Honor. Andrew Gilchrist, representing appellant Roustabout Resources, and with the court's permission, if I could reserve 1 minute for rebuttal.
1 minute?
1 minute, please.
You may.
Thank you. So we go from rent stabilization in Lower Manhattan to a case dealing with a piece of property in upstate New York, Rensselaer County. And we're dealing with contract principles. So
let's get right into this contract. What is the language that you're relying on in the contract that sets up getting the subdivision approval as a condition precedent?
Your Honor, we're not positing the argument that the contract itself states subdivision approval is required or that it constitutes a condition precedent. What we're positing to the court and what the dissenting opinion below observed is that the contract at issue does require this particular deed, the reconveyance deed, to be recorded. That's clear in paragraph 3 of the option agreement.
It doesn't say when, though.
It does not say when. It's a sub-point that I'll address. My answer to that at the moment is, in the absence of a time frame in the contract, the law will clearly read a reasonable time period into the contract for performance. And that's what was observed by, again, the dissenting opinion below. Paragraph 3 certainly must be read in conjunction with paragraph 1 of the option agreement. And when that is done, paragraph 3 states the reconveyance deed plus all documents necessary to record the deed shall be prepared and filed. In other words, shall be prepared and shall be filed.
That seems
But you forgot the
mandatory
rest of the
language.
sentence.
Excuse me?
You forgot the rest of the sentence, at the expense of Tomhannock. So
correct.
isn't the sentence really about, and the paragraph, about the agreement between the original contracting parties as to who bears the costs of trying to get subdivision approval, getting the documents you need for recording and filing, as opposed to mandating that anything related to recording and filing get done on a particular timetable?
Well, not on a particular timetable. I agree with that, Your Honor, because again, the option agreement doesn't provide a time. But we do think it is the only reasonable interpretation of that first sentence of paragraph 3, that it mandates the reconveyance deed be prepared, both prepared and filed. It does say at the expense of Tomhannock.
Let's say we agree with you that that it's a reasonable amount of time, but it does require recording.
Yes.
Why do we have to read it to require recording before you transfer the deed?
No. And certainly the Supreme Court read that, and in some respects the majority opinion below. That certainly cannot happen. Obviously the deed
Why
must
not?
be
I'm asking you,
recorded.
Where does it say that in the option agreement?
Paragraph 1 clearly indicates, upon exercise of the option, in this case I'm representing a subsequent purchaser, but we'll call that party Roustabout, must execute the reconveyance deed. That, though, read in conjunction with paragraph 3, provides the mechanism. The reconveyance deed, and this language is critical, I believe, to the court's analysis, together with all documents necessary to record the deed, shall be prepared, we'll talk about the record in a moment, and shall be filed.
At the expense.
Correct, at the expense.
And that's the end of the sentence.
But the mandatory direction of that, read in conjunction with paragraph 1, is two mandatory requirements. Prepare the deed, file the deed. And as
It
the lower
seems that the
courts-
two paragraphs are doing different things. And if the parties wanted it to do what you were suggesting, they would have been very clear about that. That you
Well-
don't convey the deed until you've done what's required in paragraph 3.
When you read together paragraph 1 and paragraph 3, I do believe the dissenting opinion that the appellate division read them properly. And here what the lower court dissenting opinion said, the two-judge dissent, was read together, once the option is exercised, prior to actually executing the reconveyance deed, precedent to that, not a condition precedent of subdivision approval, but precedent to executing the deed, is it must be prepared by Tomhannock. The record shows in this case that, in fact, that was done. What else needs to be prepared? All documents necessary to record that deed, likewise prepared by Tomhannock.
But isn't underlying the recording of the deed a requirement that you get subdivision approval by was it the planning board or was it the zoning board? It was the planning board of the village, all
Correct,
right.
yeah.
So, and quite often in agricultural areas or rural areas, there's a resistance to increased subdivision. And that takes the form of somebody buys a piece of property, they won't let them subdivide it because they don't want the land turned into housing complexes versus agricultural land, and the board makes a public policy decision to do that. That's where the requirement to file the subdivision with the deed, the subdivision approval with the deed comes from. Is that correct? Go ahead, tell me why I'm wrong, it's
No,
okay.
in part, Your Honor, you're correct.
All right.
And that really kind of gets to the second point, and it's a critical one, I think, for the court to consider.
Well, my question is this, is what are the public policy implications if we don't go your way? What are the public policy implications in those communities where this approval is required?
Well, and I think they're critical, and they're critical statewide, not just in upstate rural areas. Let's focus on the subdivision requirement. I must tell you, as a land use practitioner, when I first addressed this case, it didn't sit right with me. And the reason for that is this particular parcel, in the record it's called the whole parcel, itself was created through a subdivision. It was a 3-lot subdivision.
Right.
Went through the review, plat was stamped and signed and filed.
Has there ever been any review here at all? Has there ever been any submission at all for, or any subdivision application put in at all?
Subsequent to the initial 3-lot approval, Your Honor, the record does not show that. We know through a certain point in this case, because we confirmed with the relevant town, it had not,
I see.
and the record does not disclose it has been to date.
I see,
Okay?
okay.
Now, the policy implications. The subdivision regulations in New York clearly are designed to promote public health, safety, welfare. It requires municipal review if any lot is to be divided. It goes hand in hand with zoning requirements. It's the underlying land use policy under the town law. It's to make sure that these land divisions meet certain requirements that promote public health, safety, welfare.
But
What
the
we've
local
got-
law here doesn't prohibit the transfer of title
Well, let's take a step back.
without in advance getting the
Let's-
approval.
Let's take a step back, which is, I think it's appropriate to start with the New York State town law. When we start there, under Section 276, that state law defines what a subdivision is. And it's clearly the division of any lot into 2 or more parcels, amongst which is for the purpose of transfer of ownership. I submit to the court that's exactly what this option agreement was entailed or designed to do. And as such, under the town law, it meets the definition. Once you divide that whole parcel to create the reconveyance parcel, that's a subdivision. And I tell you, as a land use practitioner, that's what caught me at first. This doesn't seem appropriate without municipal review. Not as a condition, express condition precedent in the option agreement, but just as a matter of pure subdivision and land use law. So we look at it further.
Well,
What
it
this-
may make sense, but the question is whether or not that's what the parties bargained for.
That's correct. And that brings us then back to, I do think there's significant public policy implications of allowing a private contract with judicial approval to evade what is otherwise mandatory subdivision review. I think that's absolutely critical from a public policy perspective. We do think the option agreement does provide for that review through the necessity of recording the deed. And while my light is on, if I could answer.
Yes, please.
Any subsequent purchaser standing in the shoes of my client who comes to this parcel, the only notice they have is what is of record, and that's the option agreement. And so when reading that option agreement, we propose to you, when it speaks of preparing and filing, preparing documents necessary to record a deed, any party standing in that subsequent purchaser would think that's appropriate. If I have to do this, it will be legally created. I will need to transfer it back. What happens if that doesn't happen? It impairs my property rights. That's the other part, and I'll speak to this in the rebuttal. It leaves the property owner in my client's position with impaired title of record. That's another important policy decision that, with the lower court being maintained, sets a very bad, I'll submit, very dangerous precedent from land use perspective. Thank you, Your Honor.
Thank you, counsel. Counsel?
May it please the court, Tom Spain on behalf of the respondent, Tomhannock. Your Honors, the agreement that's at issue in this case is very clear. It's unambiguous. It's not, the only fair interpretation is the interpretation that the trial court and 2 panels of the appellate division gave to it. They declared that there was no requirement that the respondent in this case, that Tomhannock, have to get subdivision approval for this parcel.
Counsel, let's say we agree with you on that. What about this, let's call it a public policy argument about recording the title and the effect on the, let's say, the residual landowner?
Well, let me say this, Your Honor. If there's a deed delivered in this case and it's not recorded, the only parties that have any risk involved are my client and the appellant in this case. The town is not harmed in any way. I submit that this...
Well, what about subsequent purchasers who don't have adequate notice?
That notice should come from the appellant. When the appellant took title to this property, Your Honor, that agreement was on record. They had full record notice. They had the opportunity to consider their purchase before they did it, and they went ahead and purchased the property. You know, I don't know that I can sit here and espouse the rules as to what a seller of property has to disclose to the buyer, but, you know, there should, if there's an issue with that, that should come from the appellant if he's going to sell
Well,
it
a
to
future
someone else.
purchaser is going to see the option agreement, right?
There's no question, in the litigation that's been filed as well.
You know, there's one thing that strikes me about this, and I wonder if the appellate division analysis was correct on the distinction of remedies that apply here. Let me just explain what I mean. Here, if the plaintiff was seeking monetary damages in a breach of contract action, say, then Roustabout would, they could not use the plaintiff's failure to obtain subdivision approval as a defense to the breach. You see what I'm saying? Mm-hmm. All right. However, here, we're talking not about a breach and monetary damages, we're talking about an equitable remedy of specific performance. And that means that you, Tomhannock, must show that they're ready, willing, and able to perform. So the burden is then on you, on the ready, willing, and able part. How do you meet that?
Your Honor, Tomhannock at all times...
In other words, to be eligible for specific performance and the remedy that was given to you. That's my question.
I think I understand it, and I'll try to answer it.
Right.
Tomhannock has always been ready, willing, and able at the time that it exercised its option. The agreement was filed in the clerk's office. That agreement required that Tomhannock pay taxes at 22% of the rate during the term. Faithfully, they paid those taxes.
Well, I guess, I think you're right, you did all that. The only real question in my mind is you never applied for the subdivision. So how come?
It's not required by the agreement.
I see.
So I guess your
and
position-
filing the forms doesn't, I'm sorry, filing the forms as laid out in the filing of the deed doesn't seem to require that?
It doesn't. That goes back to the construction. Paragraph 1 of that agreement, Your Honor, says that the appellant in this case, or the owner of the property, if you will, has to execute a deed. Paragraph 3, as interpreted and construed by the trial court, I think, most elaborately, says that delineates whose responsibility it is to do what. Pay the fees, prepare the documents. There's nothing in that agreement that says that specifically that there's subdivision approval. There's nothing that says that that Tomhannock filed a deed.
Here's the problem sometime with these cases, and the inadequacy of the record. It's do this study, probably run across it before. If the record could answer the question, my question would be, has anybody gotten subdivision approval in this county? Has anybody gotten subdivision approval in this town? Are they blocking all of them? Are they blocking all of them because they made a policy decision to do that? So therefore, it's impossible for you to go ahead and do that one way or the other because you figure you're going to be rejected anyway. The record doesn't answer those questions, but it underlies my question about public policy before.
And I think I started to answer the question about public policy. You know, the town isn't harmed here. I mean, I think Tomhannock has expressed an intent to go and get the property subdivided. It knows it can't do anything with it unless he can't build on it, they can't resell it, they can't do anything unless they have the proper subdivision. With the exception...
You're prepared to live with the consequence of owning a parcel that you can't build on and have to pay taxes on.
Correct. One option that they do have is perhaps to annex it to adjoining property owners. I mean, that's within the town code, doesn't require subdivision approval, and I suspect that, you know, a deal could be made with, you know, an adjoining property owner.
So let's say we agreed with you, specific performance is ordered, conveys the deed, you've got title. Your position is that then, let's say Roustabout continues to own the rest of the acreage. They could not then seek approval, correct? And try and record it themselves, correct?
That's incorrect, Your Honor.
Okay.
And one
Tell me
thing
why.
that I think failed, you know, to be developed in the lower court is that if Roustabout has this burden, they have this parcel that they can't do anything with because it's unclear as to who owned what, let them go to the town and get subdivision approval. They can do that. There's a defined description of both parcels. Now, there's no requirement in the law that they do it, but if they're so harmed, they knew that the possibility existed that we would come to this point when they purchased the property.
So does the provision in which the DeLallos gave you the power to make municipal applications necessary for the reconveyance allow you to do this all yourself? Does that survive?
Perhaps. Perhaps. Consider this, Your Honor. This option agreement was filed in April of 2002. The original grantor, the original party to the option agreement was DeLallo. In 2005, DeLallo conveyed that property to the Laportes. And from 2005 to 2011, the Laportes owned it. Every time that there was a tax bill, Tomhannock paid its share faithfully. It complied with the terms of the agreement. In January of 2011, it exercised the option. It wrote a letter to the Laporte, the then owner of the property, and said, we're exercising our option, here's the deed. It was ignored. There was no response. In July, Laporte transfers the title or sells the property to the appellant in this case. No explanation to Tomhannock, no response to the exercise of the option. The property goes to Roustabout. And then keep in mind that Roustabout it's a New Mexico corporation with an Alaska address. And at some point, Tomhannock finds out how to contact them, sends them a letter, and they respond. And their response is that the option agreement is unenforceable. Unenforceable because of some provision relating to there not being a clause in the deed about the option agreement. Nothing about subdivision. This court can conclude, I believe reasonably, that there was no intention ever for Roustabout or the owner at the property at the time that
Is there anything in the record that suggests that perhaps $55,000 wouldn't be the going price these days for that?
We don't have anything, Your Honor, to that extent. I mean, at the time this was bargained for, it was apparently worth $55,000, and that was in 2002.
Let me ask, so what does this language in numbered paragraph 3, as you see it, refer to? Application for required municipal approvals for the reconveyance of the reconveyance parcel. It says the word is, I think it's supposed to mean as. Such are deemed necessary or desirable by Tomhannock. What does that mean? Deemed necessary or desirable by Tomhannock. Does that mean really that
It's
Tomhannock could say,
discretionary.
I don't want to file it?
Yeah. Or I don't want some written instrument. What they're required to do is execute a deed. In its simplest sense, that's what the agreement means. And that's what we're asking for in this action. Knowing full well the consequences. Assuming that risk.
What about his argument related to Town Law Section 276?
There's no town law that's violated here. There's no town law that prevents the transfer of title. I think significant in that argument is Section 244 of the real property law allows the transfer of title upon the execution and delivery of a deed. That's it. Town law is not violated because there is no subdivision as of the date that the deed would be delivered.
Thank you, counsel.
Thank you, Your Honor.
Counsel, if we find the option contract is unenforceable, can Tomhannock sue for return of the $55,000 and the percentage of the tax that they paid?
One easy answer is I may not need to speculate because the only thing sued for here was the equitable remedy of specific performance. And so I agree, Your Honor, that that does require Tomhannock to show that it's ready, willing, and able to fulfill its contractual obligations once this ripened into a bilateral agreement. We submit to the court that the language of paragraph 3 is clear and does require preparation and, most importantly, filing of the deed, recording of the deed. Part and parcel of that, in order to legally record the deed, that's what implicates subdivision approval. I bring the court's attention again in the record to the RP 5217 form. This is part of a parcel. The law requires, upon recording that deed, to indicate to the county clerk's office and the taxing jurisdictions that this is in fact part of a parcel.
But counsel, you could have written this contract to say exactly what you would like us to interpret it to mean, and it doesn't say that. So it seems to me this comes down, and you're familiar with our case of Voorheesville, if I'm saying the name right, Rod and Gun Club, where it was an issue of marketability because they didn't get subdivision approval. And at the end of that, we said, we're not going to say this title is not marketable because you didn't draft your contract right. So if you want this, go do it. And it seems to me this is the same kind of case. You have a contract. Say we interpret this contract to mean that this isn't a precondition. They fulfilled it. It seems like you're asking this court to override that interpretation based on policy concerns. And why should we do that?
No, not at all. What we're asking the court to do is to take a look at that language. The result sought by Tomhannock, and indeed found by the lower court, the language, if it was to be made clear, should have said in paragraph 3, the deed and all documents necessary to record the deed shall be prepared by Tomhannock, and if Tomhannock chooses to record, then it shall also pay. It doesn't say that. It says shall prepare and shall file.
Let me ask you this.
That's mandatory.
Let me ask you this. If we disagree with you,
Yes.
and we find that the language in the contract, we interpret that contract to mean that this was not a precondition, are you asking us to overrule that interpretation based on public policy concerns?
Not just public policy concerns, compliance with state and local law. I asked the court to pay close attention to the town law and the local subdivision regulations. And in terms of a poly decision, please consider also the impact to the marketability. It's not a transfer issue, it's not a sale issue. It's creating a cloud on title through private contract.
Is he
And anyone coming-
correct that you could, or your client could seek to actually file and record? Even if he doesn't want to, doesn't do anything about it? I mean, you might be able to sue him for the costs, but is there anything that prohibits you from doing it, or your client from doing
I
it?
think the clear intent of the parties, and by the way, there's nothing in the record to suggest that Tom, or strike that Roustabout came to this property never intending to comply.
No,
That's
but
mere
I'm just asking
speculation.
my
But
question. He said there's
could we?
no legal obstacle
Well, I
to
would suggest-
Roustabout trying
Right.
to go ahead and seek the approval and then record.
I would suggest to the court that what is clear from the intent of this agreement was that it was Tom
No, I
Hannock's
understand
response.
that's your argument. The
Right.
question
To the
is, are
extent
you
of
arguing there's a
providing-
legal obstacle, however, to Roustabout doing that?
Well, in part it does, because what you would then be asking this particular party, think about why the option agreement provided the interest coupled with the power. Okay? The reason for that is when the application is made, this particular applicant does not own all the property, the whole lot that would be divided. Roustabout does not have that power. We could not go to the town and ask to create the reconveyance 3.5 acre parcel and out of the whole parcel, because at that point, we don't own the 3.5 acre parcel. If the court's order granting specific performance requiring transfer to title, my client no longer owns the 3.5 acre parcel and has no legal right to make an application for subdivision, which includes that. So that's why the option agreement sets up with granting Tomhannock that power under the contract to do it.
But your argument is he's got to do it before he's the owner.
He must.
So why can't you do it when you're not the owner, if he can do it when he's not the owner?
Well, as we stand here today, Your Honor, my client is no longer the owner. There has been a deed executed. We are not legally entitled. It's being held in escrow, but we are no longer the owner of that property.
Thank you, counsel.
Thank you for your time.